From question.
So you're obviously aware of the changes to the Civil Aviation Act in October last year.
Certainly.
Can I get an understanding of what CASA has done in response to that change in legislation? So have you set up committees? Have you set yourself objectives? Those sorts of things to achieve the command in the provisions.
Senator, the provisions are very clear. It is a requirement for us to take cost into account, I think, in the development of essentially take cost into account in the development of manuals of standards and other things, which is what we do, and we have a process in place to do that. I might bring Dr. Alec up to the table if I may, because he may be able to speak to it more accurately than I can.
So the requirement is that you consider the economic and cost impact on individuals, businesses,
correct,
and the community, and that you take into account the different risks associated with different industry sectors. Can I just maybe just to help the context of where I'm coming from in this question, the Parliament and indeed the government and the Parliament developed this out of the concern that people have expressed to various committees over time as to the increased regulatory burden. And so I would be hoping that this is not just being seen as some small issue, but that you genuinely are looking at ways in which to reverse the trend that people are telling us about.
Senator, we do genuinely look at cost. We look during the technical working groups that have been referred to today. It would be fair to say that industry members are always referring to cost, and we're always considering trying to ensure that we do not increase I'll call it cost. I'm calling it cost in the broad, the burden on industry, and trying to reduce that. And we have processes in place to do that. And Dr. Alec might refer directly to the legislation. We're trying to make sure that we're absolutely compliant with it. I think that people have different expectations of what it might mean and how you would apply it.
And that's what I want to get out on the table. So I have a definite view on what that means, and I'm trying to understand what CASA's view in respect of that change directed by the Parliament.
Jonathan.
If I may, Jonathan Alec, Executive Manager, Legal International Regulatory Affairs. We were very conscious of that change, very well aware of what it would imply. The language, as you probably know, Senator, was taken almost verbatim from the Minister's Statement of Expectations. And at the time, we were aware of the fact, as were those who participated in the introduction of the legislation, the second reading speeches, that this provision enshrines what CASA was meant to have been doing anyway. That those expectations about taking cost and risk into account are expressed in our regulatory philosophy. They're expressed in the director's directive that's been around about risk-based legislation. And by putting it in the Act, in the course of the second reading speeches, it was made clear that this was making the importance of that expectation as clear as it could possibly be. So, legally, of course, it creates a duty, a legal duty, where previously there was an expectation.
Sure. So if I listen to what you're saying that's business as usual because you felt that prior to that point you were doing that anyway.
Well, we did, but I must say that cognizant of the fact that this was now a legal duty, we made it very clear that as this is now a duty, the expectation will be that we'll be able to demonstrate in a much clearer way how this was done. We provided guidance and direction to our those in our organization who are responsible for developing standards under the provisions of the Act that are referred to in the amendment. What these terms mean, these terms take into account, have regard to, these are terms that have been dealt with in legal context. So I said, if you're going to comply with the law, you need to know what that means. And it does actually impose a new discipline. And in the process of developing...
So the burden of my original question was, I don't necessarily want to get into a legal discussion. I want to know what CASA has actually done. So, and maybe you can do this on notice. You can spell out, look, this legislation passed, that caused the board to do this, that flowed down to this activity being carried out, these new KPIs being set. Okay, maybe that could be done on notice.
For your notice, Senator, if that helps, noting the time,
Yeah.
what we have implemented to implement the change.
Okay.
If that would help, and then that can be subject to further questioning.
And you know, any objectives that have now been set. And I wonder if you could, or maybe not on notice, but do you see this as something that needs to be applied retrospectively to not in a legal sense of placing the duty on you before the legislation was passed, but looking at the current legislation and looking and saying, how do we take that legislation or those regulations that are in place and now fit them to the new legal duty that you have? Is there any effort being conducted in respect of that?
There is not, Senator. I've looked at it in a slightly different way, but with the same outcome, and that is we worked very hard to complete the regulation suite because it had been going on for so long, and therefore various iterations of that regulation suite came to life at different times, if I can put it that way, over the last 25 years. That's why my focus was on completing the regulation suite, because my strong view is that we need to look at the entire regulation suite again. But we couldn't change horses midstream. We improved the way we do regulations, but we couldn't change it midstream. And within the context of that, reducing the regulatory burden is a clear element within that. But we needed to complete.
Okay.
Stop arguing over the first bit.
I understand the proposition you're putting. Thank you very much. But the second part therefore implies that you might be rolling out a plan, having completed the regulations, to now walk back through these regulations and say, how do we get these things, and I'll use the words of the witnesses, looking like New Zealand's, looking like the FAA's and so forth.
And Senator, to be frank, we're actually doing that. There was discussion today about Part 61. There's a ongoing review, a technical working group of Part 61. Part 61 exists. We're endeavouring to streamline Part 61, change it, make it more fit for purpose so that we will be able to change Part 61. Okay. So a lot of those things are alive in the context of the work we do. But I was talking more generally about the entire suite. And we also said to industry, what are the regulations, aside from the fact that we're trying to complete, what are the regulations that bother you most? And Part 61 is one that bothers the industry most, so we focused on it.
Okay, so if you wouldn't mind just explaining in a story about what you've done as a result of that, you know, meetings, objectives, what outcomes you've met. But I will go back to one other point. This is my last line of questioning, Chair. It was raised in the hearing. It's clear that you were listening in relation to Part 138. So that is a regulation that I understand is being worked on post the changes to Section 9.
The regulation was made and the Manual of Standards has just been made, Senator, yes. Okay,
okay. So this is a regulation that has been put in place after the change in Section 9 of the Civil Aviation Act. Now, it was put to us that the technical working group went through a process, pushed some dissenting or provided a dissenting report in respect of the propositions of CASA. I know you said that you engage in consultation. The evidence we've heard today in relation to that particular committee was that it was not necessarily consultation with, but consultation to. And you're allowed to push back on that. But what I would like to see, and I did ask the witness to provide us some information, but from your side, perhaps if you could show us, and this is what I'm particularly interested in, you clearly developed this Part 138. I'd like for you to demonstrate to us how, in engaging with the technical working group, that might have brought about at least some changes to the regulation. I'd also like to see their dissenting report, if you could provide that to the committee. I just want to understand that particular process, and I want to see how the engagement occurred and what the result of that engagement and consultation was.
Senator, certainly. I listened to that dialogue today. Let me be absolutely clear. There is nothing in that process that is not available to this parliament.
Sure.
So we will provide all of the material around the technical working groups. So there was a discussion about could we before. Obviously, we would do that.
Sure.
There was some...
I think the witness was just being cautious.
Yes, I believe so too. That technical working group has been, in one form or another, going for nearly 20 years. Mm-hmm. The technical working group did, at the end of the day, have a dissenting view, and that's not the first time we've had a dissenting view. The Aviation Safety Advisory Panel received that advice and discussed it, and they came to the conclusion that they would recommend, regardless of there being dissenting views, the amount of work that had gone on within the development of Part 138, the significant work that had reduced it from 200 pages to 75, the significant changes that had been made during that discussion, they would recommend that the Manual of Standards be made. So as a consequence, that recommendation came to me, and I made that Manual of Standards. Sitting behind that, I'm very happy to provide all the documentation that supports how it got to where it got to, and you'll see the changes, the iterations, the dissenting reports, etc.
That's what I'd like to see. Now, the other point that was raised, and I'm happy to do this in a de-identified way, but that the proposition was put that the experience levels in terms of people who actually fly, people that own a business and so forth, was much greater on the technical working group than it might have been on CASA's side of the ledger. So I invite you to perhaps de-identify the people, but just say these are the people involved, this is the levels of experience that these people had. And I'm only talking about over the last year or so.
Certainly. Senator, happy to. I'll make the point just on that reference that one of the key drivers in the technical working group who was working directly for me for a while and went back to Part 138 about 6 or 8 months ago, has a commercial pilot's licence, commercial helicopter pilot's licence, and has flown in Australia with his helicopter domestically and has flown internationally. And my view is that he is well versed in rotary wing operations. So I'm very happy to put that on the table, and I'm very confident in the young man and his ability.
Sure. I'm actually giving you the opportunity.
I agree, and I will do that. Very happy to
lay that out. I think I've probably used as much time as I'm allowed. I'd ask more questions if there's time.